Okay. They're going to give CDs to the clerk, and the clerk is going to hand them out to people who request them. That is what they have agreed to. I find it interesting that it says council has received limited outreach for the audio file to date. Come on now. We all know that there are hundreds of creators, media companies, private people, Clark, looking for these files. But this is how they have agreed to do it. This was never really like anything. I don't think Wayfair cared how this got out, because they're like, we're not the ones who attached it to emotion. We're not the ones who brought it into the case, and we got it from you. Remember that in the declaration of Claire Ayub, it has a Blake Lively Bates stamp on it, which means that Wayfair got it from Lively. So if you're Wayfair, it's like, I don't care. Do whatever you want. But we're not going to put it out there. We're not the ones who brought it up, and we're not the ones who put it in the case. And whatever we have is just a copy we got from you. So you need to figure out what you want to do. So my guess is they probably would have agreed to pretty much anything. On the Lively side, they really only had a couple of options. They could have Claire do it. They could say, it's your recording, you put it out there on your Instagram profile or something. We, Lively, will put it somewhere. I don't even know where they would put it. We'll post it on a public site. We'll do something with it. We'll make it available to people at Manat, right? Call this number at Manat and we'll give it to you. Which I also think they don't want to do for a lot of reasons. Or they could do this. This is, for the Lively team, the best option because it gives the recording to a neutral third party, which is the clerk of court, and keeps Manat out of it, right? So I think that for the Lively people, to the extent that there was risk associated with giving this out to the public, this is probably the best outcome they could have hoped for, the best plan they could have come up with. Now, we don't know when. It just says they have agreed to provide. We don't know when they're going to provide. I don't know. They didn't say when, and they didn't have to. The judge just said by today he wanted a letter about the progress of their discussions about how this was going to be made public. So, it's 4:38 right now. The clerk's office is probably only open till 5. Most are. So, I think it's probably safe to say we're not going to see it, or hear it rather, until next week. But who knows? Anything could happen. Obviously, the clerk's office is closed on the weekends. But, once one person gets it and posts it on the internet, it's going to, go around. Then it's not really going to matter. If you're the actual, media, if you're the legacy media and you have any kind of standards for reporting, I know, they're going to have to get the original one from the clerk to make sure that it's real. But the rest of us don't. So somebody will get it, and then within, 20 minutes, we'll all have it. We still don't know if hearing it, it's about 29 minutes long, according to the declaration. Well, maybe not. Maybe it's actually longer than that. The last time they cite in it is minute 29 something. So it could be longer than that. We don't know if just the recording itself will give us the information to know where both of the parties were, which will allow us to determine whether it was an authorized recording or not. We still don't know. I don't know if someone's going to answer the phone and say, hi, it's me, I'm in Chicago. I don't know. So hearing the recording itself might not answer all of those questions. But like I said before, I think that the Lively people do not want to be the firsthand giver-outers of this information because they want to distance themselves from its authenticity, because they can't guarantee its authenticity, because they didn't get it through the normal discovery processes. Someone just handed it to them, right? So, I think this makes sense, but I think we still may have gaps depending on how the information, what the content of the information is. And I just want to remind everybody, Judge Lyman deciding not to permanently seal this information was a really big ruling. It was one of the biggest rulings he's made in the case, because he had agreed to seal pretty much anything that anybody asked for on both sides, even a lot of third parties. He said, okay, if you want me to seal it, I'll seal it. Because, you err on the side of protecting people. It's something I say to clients all the time. We can always make private information public, but we can't do it in the reverse. Once it's out, it's out. But when he ruled, and Lively had asked for this to be permanently sealed because they were worried about people going after the declarant, the judge was very specific that these are circumstances in which the public has the right to know. And he cites this law that talks about, presumption of public access, and talks about dispositive motions, and then says, courts have also applied the strong presumption, that means the presumption of public access, in the context of motions for sanctions, given that these motions too determine litigants' substantive rights. What he's saying there is, when you file a motion for sanctions, when you ask the court to punish someone for misuse of the court system, which is what a sanction is, that is a matter of public concern. Okay? And the public deserves to know what your bases are. And he then goes on to say how, yes, there are interests in her privacy in this case, but they're not enough. He says, her underlying motions for fees and costs and all the damages, whatever. This is the kind of motion to which a strong presumption of public access applies. And the privacy interest, this person's identity, is not enough to overcome that. Public access matters when it comes to sanctions. And that's really important because he is telling us that he sees motions for sanctions as different from other motions. He sees motions for sanctions as a very serious matter, and he sees them as a place where there is more need for public access than there is with other kinds of motions and other kinds of filings. And that's good information to have, because any information you get from a judge, even if you get it sideways, is information. And then he says, blah, 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 the declarant's identity is not also unverified. That's what Gottlieb had said, is unverified. And the judge was like, no, it isn't. And by the way, this person voluntarily submitted this. They knew what they were doing, and they'll be okay. And so I think it's just worth taking a moment to realize that it would have been really easy for him to just be like, sure, we'll keep it sealed. I seal lots of stuff in this case, whatever. But in his mind, this motion for sanctions, asking for treble and punitive damages and attorney's fees, was different to him and had different meaning and different rules about what was attached to it. And I think we ought to take the information, like I said, all data is good data when you're looking at how a judge sees things. I forgot this. Also, the judge, citing that law that there is great public interest in public access to dispositive motions, means that he is going to be more likely to let us see whatever evidence is filed in support of or in defense of, in responses to, the summary judgment motions. And that is good, because we have been very worried about that because of the AEO. But he is signaling here that he believes that when there's a dispositive motion, because that's what a lot of those cases say, when you're talking about getting rid of a case, even more so in a sexual harassment case, the public deserves to see why. So I think that's a good sign also.